All right, let's get started, everybody. Let's close down the music. Come on. There we go. The tip of the spear. Here we go. Page in the PDF 46. A legal jailbreak. Let's find out what it's going to say. It was in this context that the Branch Queens became the site of a bail review, hearing unlike any that had occurred previously or since. During this press conference, the rebels announced their plans to expose the violence of the bail system. They released two hostages as a show of good faith and promised to release two more if the New York State Supreme Court judges were brought to the jail to review their cases. If this did not happen, however, the rebels would announce their readiness to carry out executions. The authorities conceded, a decision that took them into uncharted legal territory. As one official noted, quote, we were being asked to set a legal precedence that was logistically impossible and probably illegal. Figuring things out on the fly. The coterie of judges. Hold on, let me look up this word. If it lets me. Hold on, right back, everybody. It's coterie. Sorry, everybody. Coterie of judges, mayoral aides, and attorneys convened in the Manhattan office of Frank Hogan, prosecutor in the Panther 21 case. They were examining the case files and court records of the 47 bail candidates who had been selected by the rebels. As per a previous agreement, none of the Panther cases would be reviewed, nor would any involving homicide, armed robbery, or kidnapping. And so it was that for several hours on October 3rd, 1970, a 3-judge panel held court on the grounds of a jail controlled by criminals, radicals, and revolutionaries. Lawyers, police, media, and the elected spokesmen of the rebellion packed the small anteroom. One by one, the judges seated at the end of the long conference table called the names on the first list. Fresh out of law school, Gerald Lefcourt, a young white attorney for the Panther 21, had no doubt that his clients would have killed the remaining hostages had the hearing not taken place. They were all so serious, he recalled, and the Panthers were facing life and assuming that they would do life. Gilberto Jimenez was the first name called. Like all who came after him, he stepped forward named Lefcourt as his legal counsel. Jimenez had been waiting trial on a charge of possessing stolen property. The judges reviewed his case file and criminal record, conferred briefly with each other, and similarly reduced his bail from $500 to $0. Although he was still facing charges, he was now free to leave on his own reconnaissance. The sound of the gavel rapping against the table signified the finality of the decision. Jimenez was then escorted out of the gates of Branch Queens, but not before embracing each of the organizers in the show of gratitude. He immediately joined the Young Lords Party and continued to support the revolt as part of the ILF. The judges reached the same conclusions in 8 other cases, reducing established bails to $0 and cutting captives loose on the spot. In addition, 4 men had their bails reduced to $25 each and were also able to walk out the front gate after the supporters amassed outside pooled the $100 necessary to post the bails. All told, 13 men many of whom had languished in jail for more than a year, were set free in the matter of hours. This was an astonishing confirmation, not only of the captives' long-standing indictment against the state for conspiring to keep them locked up, but also of the legitimacy of their rebellion and their use of political violence. The local politicians was convinced that, quote, had the judges stayed to hear all 460 cases, at least 400 of those men would have been freed on the spot. This didn't happen. Instead, after presiding over these initial cases, the judges disregarded the other 35 names on the list, terminating the hearing. While he was pleased to see Jimenez and the others leave, Balaguer saw the reduction of the token gesture. Quote, they didn't dig submitting to anything close to justice, but just as much as they had to, he wrote later. As he sat in his Manhattan office and discussed these events nearly 50 years after they occurred, Lefcourt said the experience was, quote, one of the most unusual things I've ever lived through or heard about. It was the first ever legal jailbreak, end quote. His apt pairing of the autonomies, legal and jailbreak, exposed how the rebels' mobilization of collective disorder and law-breaking produced a favorable outcome that was sanctioned by law. In that small anteroom, I don't know. The objects of the law stabilized the state's monopoly over the legitimate use of violence and exerted power over and through the agents of law. Under the threat of violence from below, the legal system surmounted its massive backlog and circumvent the procedural of inefficiency, quote unquote, that were supposedly the cause of the ballooning detention population. And even the event had a profound impact on the court's political development, and that of a whole generations of radical lawyers, whose increasingly came to understand themselves as a legal support arm for the revolutionary movement unfolding on the streets and within the jails of the United States. Imprisoned revolutionaries approached the hearing as a means of delegitimizing the state, given the rebellion's incapacity to win a Gramscian war of maneuver against the militarily and technologically superior enemy. They organized the hearing as an act of political theater, dramatizing the legal system, derelictions of its duty to provide equal protection under the law for the sizable fraction of its subjects. As a result of their militant action, human beings were released from the teeth of the state, exposing the violence and judicial discretion, and affirming the rebels' claims that they were being subjected to a genocidal conspiracy. Yet, there was a contradiction here too. By forcing the judiciary to adhere to its own standards, that the criminally charged should be presumed innocent, by granting due process of law and receiving speedy trials, their legal jailbreak could be viewed as an acquiescence of the state authority. As legal theorist Isaac D. Delbus explained, quote, those who would argue that delegitimization can result from the failure of law to live up to its promises, fail to understand that the legitimization of the legal order is not primarily a function of its ability to live up to its claims or redeem its pledges, but rather of the fact that its claims to pledges are valued